defendant on assault with intent to murder, felony firearm, assault with intent to do great bodily harm, less than murder or by strangulation, and felony.
Mr. Ganatra, sir.
Good morning, Your Honor. Nimish Ganatra, First Assistant Prosecuting Attorney on behalf of the people. Your Honor, at this time, the people move to waive any potential conflicts between this honorable court and the Office of the Public Defender. The prosecutor's office does not believe a conflict exists, but if there is one present, we waive that for all the cases today between the prosecutor's office and the public defender's office before this honorable court. Thank you.
Thank you, sir. Mr. Brown.
Good morning, Your Honor. Lauren Brown, Deputy Public Defender. Your Honor, we likewise do not believe that any conflicts exist in this court hearing these matters. If any conflict were to arise, we would waive that conflict in order to allow this court to hear these matters.
All right. Thank you, sir. The court also, for its part, does not believe that a conflict exists either under the Michigan court rules or the cases decided thereunder. To the extent a conflict exists, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Nathan Berge.
Good morning, Your Honor. Laura Willenberg on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Berge. Mr. Berge, would you please state your name for the record?
Nathan Lawrence Berge.
Thank you. I have before me a plea form. Is that what we're doing today?
That is correct, Your Honor.
Yes, Your Honor.
All right. The plea form indicates defendant will be pleading guilty to the charge of use of a controlled substance, the 1-year offense. Upon his successful plea to that charge, the felony charge would be dismissed, that being count 1. There is no other agreement. That's the court's full understanding. Is that correct, counsel?
That's correct, Your Honor.
Yes, Your Honor.
Thank you. Mr. Berge, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Can you state your name for the record again, please, sir?
Nathan Lawrence Berge.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That is a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Understanding, well, I also should advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on parole or probation?
No, Your Honor.
Has anybody promised you anything other than what's been discharged?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Sir.
And because you believe that you're guilty?
Yes, Your Honor.
July 27, 2021, at the location of Michigan near Summit, City of Ypsilanti, Washtenaw County, State of Michigan, did you have a controlled substance containing fentanyl in your possession?
Yes, Your Honor, I did.
Had you used it?
No, I just got caught with it.
Okay. Was your intent to use it?
Yes, sir.
All right. You knew what you were using was fentanyl?
Yes, sir.
All right. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Yes, thank you, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14A2 District Court. Sentencing in this matter will be
June 28th at 11 a.m. with Judge Barr.
June 28, 2023 time
11 a.m.
at 11 a.m. That is before Judge Barr.
Your Honor, may we address bond, please?
You may.
Your Honor, Mr. Berge is currently at the Livingston County Jail. I have been able to confirm with the Livingston County Sheriff's Department that he will be released on June 18th. We're requesting a personal recognizance bond in this matter. We had previously.
What's his current bond set in?
I believe it's 1,010%. Pardon me. That was set in, I believe, April, because so that he could earn credit on these cases. It had previously been, I believe, a PR bond.
Any response from the people?
I have no objection, Your Honor, but I would ask that community corrections testing be put in place once he's
I'm
released from
looking
Livingston
at
County.
At the time of his arraignment, his bond was set at 1,010%. That was at the time of his arraignment. It also does not look like, for whatever reason, there is no community corrections order. So that they ordered community corrections. I will set the defendant's bond at a $5,000 personal recognizance bond. I will order community corrections 2 times per week testing upon his release.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Peregrine Bork.
Good morning, Your Honor. Grace Burton, appearing on behalf of the people.
Good morning, Your Honor. First Assistant Public Defender Kalina Anderson with on behalf of Mr. Bork. Mr. Bork, will you state your name, please?
Peregrine Bork.
All right, what are we doing?
Your Honor, we're asking for an adjournment to continue plea negotiations.
All right, how long are you looking?
I think we need 2 weeks since he's in St. Clair.
I'm sorry. All right. Probable cause conference, June 29th, 2023, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue. Court calls the cases of the people versus Joseph Bondville.
Good morning, Your Honor. Alex Chabalowski on behalf of the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Fonville. Mr. Fonville, would you please state your name for the record?
Joseph Fonville.
Your Honor, Mr. Fonville is at the Wayne County Jail. I was able to arrange an appointment to see him at the earliest time tomorrow at 4 or 4:30. We're requesting an adjournment.
All right. Well, let's go to the 29th so we can read him. Probable cause conference without objection, June 29th, 2023, 9 a.m. Bond in these matters will continue.
Thank you.
Thank you.
Thank you, Your Honor. All the best to you and your staff.
Thank you. Court calls the case, people versus Ivan Pasick.
We're ready in that matter, Your Honor.
Okay, we're bringing him in.
Alex Chabalowski on behalf of the people, Your Honor.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Paycheck. I believe that he'll be in shortly.
He's just outside. He's walking in now.
Say 15. I think he is present now.
Hello, Mr. Paycheck. Could you please state your name for the record?
Ivan Paycheck.
Your Honor, today is the date and time set for a competency review hearing. Is the court in receipt of any updated reports?
So I have a report dated May 23rd. Received by the court on June 1st. Do you have that report?
We do not have that report.
Does the prosecutor have that report?
Yes, Judge, we do. I believe it reflected that Mr. Pasek continues to remain not competent to proceed. However, the forensic center, the evaluator believed that he could be restored within the timeframes.
Yes, and is responding positively to current treatment. So that's what the report reads. I don't know what you wish to do, Mr. Brown, since you don't have a copy.
Your Honor, as Mr. Chabowski is an officer of the court, and I suspected that's what the court would say anyway, I am prepared to ask for 3 weeks or maybe a month to allow the forensic center to see if they can bring Mr. Pasek to competency.
Usually, well, I would set a review if he was incompetent. Usually I'm going to set that out at a 90-day time frame. But if you want me to set something in a month, I can do that. I mean, either way you want me to do it, but
No, Your Honor, actually 90 days would be fine. If he's in fact returned to competency before that, we can certainly move the date up.
Correct. All right. All right. I'm going to indicate that defendant remains incompetent. And Mr. Brown, I am going to need an order that reflects that ruling of the court based upon the report. I will set a competency review hearing for, September 7th, 2023, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. Let's call the case, People versus Bernard Fonville.
Good morning, Your Honor. Marie Rosinski on behalf of the people requesting permission to practice pursuant to Michigan Court Rule 8.120 under Assistant Prosecuting Attorney Caitlin Kirby.
Permission to practice is granted.
Thank you.
Good morning.
Good morning, Your Honor. Janelle Hamoud appearing with Mr. Bernard Fonville, who's present by Zoom from the Washington County Jail. Mr. Fonville, can you please state your name for the record? You need to unmute, okay?
Oh, you're still muted. There you go.
My name is Bernard Fonville.
Okay, I heard him. All right, what are we doing?
Thank you, Your Honor. Last we were here, we were waiting for him to be sentenced in another case to see if we could incorporate some kind of a plea agreement that would include that sentencing. That sentencing was adjourned because the pre-sentencing report was not ready at the time of his sentencing at circuit court. And if we could just get another adjournment of this date for a date after the 28th to get that sentencing completed, we'd appreciate it.
After the 28th of this month?
Correct.
I have the 29th, or did you want the following week? It's up to you.
We can do the 6th, just so that we're not in the same position where we're waiting on responses.
Okay. Hearing no objection, probable cause conference in this matter will be adjourned July 6, 2023, 9 a.m. Bond in this matter will continue. Thank you.
Thank you, Your Honor.
Court calls case, People versus Dominique Ballard Tab.
We're ready in that matter, Your Honor.
Good morning, Your Honor. Amy Reiser appearing on behalf of the people.
Senator Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Germanique Ballard Tab. Ms. Ballard Tab, please state your name for the record.
Good morning, Your Honor. Germanique Ballard Tab.
Mr. Brown, I thought you were going to say, haven't heard Ms. Reiser's voice in a while.
Well,
I thought you were going to say it was nice to hear that, but you You were just rude. Didn't do it. All right, never
I'm
mind.
just sorry.
Ms. Reiser, it's good to hear your voice again.
Thank
All
you,
right.
Judge. It's good to hear you.
Well, Your Honor, I did just see her Tuesday, but it's always nice to see you. I thought that went without saying.
All right. Okay, what are we doing on this case?
Your Honor, we're going to set this matter for preliminary examination, and we'd like to be heard on bond when the opportunity arises.
It's 27th. Set it for the 27th, or we are also hearing exams July 6th. Which would you prefer?
Your Honor, we'd ask for the soonest available date as my client is incarcerated.
All right.
We can do June 27th, Your Honor.
Preliminary examination, June 27th, 2023, 9 a.m. That will be before Judge Washington.
Thank you. So
in person, as to bond.
With respect to bond, Your Honor, my client does have a home in the area. She has no place to which she would flee. She maintains very strongly her innocence in this matter. She believes that the complaining witness is not being truthful in making these allegations. And she therefore would respectfully request that she be allowed a personal recognizance bond. She is within walking distance of the court. Certainly, she is capable of appearing before the court by Zoom, and she is asking that she be allowed to do so.
Response.
Your Honor, if you could confirm what the bond is set at, I believe it's 50,000 cash. Although I'm not.
That is what I have.
Sure. Your Honor, we're asking that the bond remains set where it is, based on the seriousness of the allegations. The Pittsfield Township Police Department received a 911 call from a juvenile who was a juvenile runaway, and the allegations are in this case that the defendant was human trafficking this juvenile. The police did make contact with her grandmother, who came and picked her up, and expressed the same concerns that she was being sex trafficked by the defendant. I would also indicate to the court that the defendant was bound over in the 36th District Court on March 22nd on assault with intent to murder, felony firearm, assault with intent to do great bodily harm, less than murder or by strangulation, and felony firearm, and carrying a concealed weapon. I don't know the status of that case. I will try to find that out. Additionally, on her criminal history in 2019, she had a conviction for Utah that was deferred under HIDA for 2 years. I don't know if she completed that HIDA probation or not from 2019, but I think more concerning is the fact that she's on bond for a 9-count felony out of Wayne County. I believe she would be a danger to the community and a flight risk. So we would ask that bond remain set where it is.
Mr. Brown, anything else?
No, I would point out that those are allegations from another district. We don't have any details or facts on that. Certainly nothing before the court. Again, she does live in this area. She does promise to return to all future court dates.
In looking at the entirety of the circumstance, does believe that the defendant does pose a risk to the community and could pose a flight risk given the other matters. It would also indicate that the defendant is on bond on the other case, which the court can take into consideration. So therefore, the motion for bond reduction is denied.
Thank you.
Let's call the case of the people versus Raheem Smith.
Jessica Blanche, appearing on behalf of people.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Smith. Mr. Smith, could you please state your name for the court?
Raheem Smith.
Thank you. All right, what are we doing?
We're asking the court to please set this for preliminary examination. The June 27th date is fine, Your Honor.
How do you know I was going to use that date? Preliminary examination will be set June 27th, 2023. That'll be 9 a.m. That'll be in person. Really? Yeah, well, I'm going to do that. That's before me. Bond will continue in this matter.
Thank you.
Calls the case, People versus Candace Brooks.
Karma, you're not unmuted. We can't hear you. Caitlin Kirby on behalf of the people.
Good morning, Your Honor. Aaliyah Gani for the defendant Candace Brooks, seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Attorney Michael Gaddy.
Can he even hear?
Yeah.
Okay, so he might be in a witness protection program still. All right, permission to practice is granted.
Yeah, can you not hear me, Your Honor? I'm sorry.
I'm sorry, what did you say, counsel?
Can you hear me?
Yeah, I can hear you.
Okay. Ms. Brooks, can you state your name for the record?
Candace Brooks.
All right, I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right, the plea form indicates that the defendant will be pleading no contest to 2 charges. She'll be pleading no contest to count 2, the OWI charge, and also an added count 5 of attempted resisting and obstructing a 1-year offense. The other offense is a 93-day offense. Upon her successful plea of no contest to those charges, counts 1, 3, and 4 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
All right, thank you. All right. And Ms. Brooks, can you please raise your right hand? You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name for the record again, please.
Candace J. Brooks.
All right. You can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading no contest to 2 charges. The first charge is the stated count 2 of operating while intoxicated. That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand that?
Yes.
The other charge is the charge of attempted resisting and obstructing. That's a misdemeanor, punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes.
Counsel, the basis for the no contest plea?
There is a NA case, Your Honor.
A potential civil liability, Judge.
Thank you. All right. Ma'am, do you understand what a no contest plea is?
Yes.
All right. Let me explain 2 things about it just to make sure that you understand. It first of all means that you're not further desirous or wanting to contest these 2 charges. You understand that?
Yes.
The other part that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes.
Still wish to plead no contest?
Yes.
To the charge of operating while intoxicated, how do you plead?
Guilty.
Okay.
I believe you'd plead no contest, Ms. Brooks.
Oh, no contest.
To the charge, let's see if we can get it on this one. To the charge of attempted resisting and obstructing, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
I'm sorry, I didn't hear that
No,
response.
no, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will?
Yes.
The court has been provided and has reviewed Washington County Sheriff's Department report for their case number 2011376. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule of these offenses? Have I complied with the court rule, and would it be proper to accept this defendant's pleas?
Yes, Your Honor.
Your Honor.
Court will accept the defendant's pleas of no contest to counts 2 and 5. Counts 1, 3, and 4 are dismissed pursuant to the plea agreement. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
July 13th at 10 a.m. with Judge Washington.
July 13th, 2023, 10 a.m. before Judge Washington. Bond in this case will
Yes,
continue.
Your Honor.
Oh, you want to address bond? Go for it.
We'd like to request bond. Ms. Brooks is doing intensive outpatient treatment as we speak, and she can also have a tether.
She is doing intensive outpatient?
Yes.
Your Honor, if I might, she also has recently obtained subsidized housing in the city of Ann Arbor. She is doing the Dawn Farm. She was doing it before she got arrested. I know this case is old. I know this case is old, but she also has a recovery coach that's helping her with the reunification process in another matter. She is well supervised. We'd ask the court to give her a personal bond and anything that she could, any conditions that the court would consider putting in place to ensure both her compliance with the court's orders and that she appear on time. She is working steady. She makes about $18 an hour at a parts manufacturing place that's a subcontractor for Ford Motor.
Response from the people.
We'll leave that in the court's discretion, Your Honor. Mr. Getty did relay that information to me yesterday when we were signing the plea form. And the only other thing that I see as she has a hold on a probation violation out of Livonia.
And Your Honor, given the bond amount, we did check on that. It's a very old case. I believe it's fines and costs, and it'll be an advise and release.
What I will do is, in this matter, I'll set the defendant's bond at $20,000 personal recognizance. Prior to the defendant's release, the defendant must be placed on a scram tether unit. I will also make a condition, an additional condition of her bond, that the defendant re-enroll in the intensive outpatient if she's to get back enrolled or continue with that.
Thank you, Your Honor.
That's it.
Thank you, Your Honor.
Thank you.
This hearing does not involve a sovereign citizen argument or jurisdictional challenge, but it demonstrates one of the most important principles in criminal procedure. Bond decisions are based on risk, not guilt or innocence. The defendant maintained her innocence and requested release on a personal recognitions bond, emphasizing her housing, employment, treatment participation, and willingness to appear in court. The prosecution, however, argued that the seriousness of the allegations, additional pending felony matters, and the defendant's criminal history created both a public safety concern and a risk that she might not appear as required. The judge considered the totality of those circumstances before deciding that the existing bond should remain in place. A bond hearing is not a trial. The court does not determine whether a defendant is guilty at this stage. Instead, the judge evaluates factors such as the nature of the charges, prior history, community safety, and the likelihood that the defendant will return to court. The broader lesson is that pretrial release decisions require balancing the defendant's rights with the court's responsibility to protect the public and preserve the integrity of the judicial process. Those decisions are based on legal standards and the information available at the time, not on internet speculation or public opinion.